all directions in the matter of Faraj and Ahmad and IIB group WLL.
Yes.
My lady, my lord, in this matter I appear with Mr. Haggie on behalf of the wife, if I may refer to her as that, given that she's the respondent to the appeals but making applications in the case. At the end of the row, Miss Bangay, King's Counsel, represents the husband with her junior, Mr. Wheel, and in the middle is Mr. Richardson, King's Counsel, who represents the bank.
Thank you.
My lady, this hearing pursuant to your order was to consider the applications made by the wife, secondly the progress of the appeals, and thirdly the question of costs. And you should have received from all of the skeleton arguments in that respect. Can I start by dealing with the question of the unless order and Hadkinson, if that would please the court? The fundamental premise on which I should mention one thing for which I apologise. It's a matter that Mr. Richardson raised with me yesterday. There's a mistake in our note, and that is in relation to the question of when the wife in the main proceedings.
Take us to.
It's paragraph 8 of our note.
Page.
Page 2.
Sorry, I meant in the bundle.
Oh, I'm so sorry. I'm not sure it's in the bundle itself. I think they were sent to my lady separately and my lord, and lodged on the electronic e-file.
I think I've read everything.
So, which document are you going to?
It's our skeleton argument.
Skeleton argument.
Yes.
Right. Yeah. Got that. Yeah.
So,
Okay, and paragraph.
8. Does my lady have it?
Sorry.
no. Excuse me. I think
The paragraph begins with the words
During the hearing. Yes.
Yep, I have it.
Thank you, my lady. It's the last sentence, which reads, as a result of this concession, i.e. the concession of the bank to allow the wife to remain in alternative property, the wife did not abandon her alternative argument that the FAT was a nuptial settlement,
Yep.
as given the concession, etc. And over the page, 5 lines down, there's a sentence beginning, given that the wife had pleaded nuptial settlement, which based on the bank's concession she did not pursue, it's very hard to see how the bank can resile from it. Those 2 sentences are incorrect, and the reason they're incorrect was at the beginning of the case, my client accepted that she was not going to pursue the question of nuptial settlement.
Right.
So there was no nexus between that
Right.
and the bank's concession, although the bank's concession does raise further questions about whether the FAP is a nuptial settlement or not, but we don't need to consider those for the purposes of today.
No.
But I just wanted to bring that to the court's attention. Mr. Richardson rightly pointed out that my note was wrong in that regard.
No,
which I
thank you very
apologise.
much.
So,
Well, actually, while we're dealing with errors in notes,
yes,
the husband's skeleton argument at paragraph 16. Paragraph 16. Refers to.
I know what your ladyship's going to say.
Yes.
Yes, my lady, it was taken from a note provided by my solicitor. It was inaccurate. I accept that, having very helpfully seen the judgment that your ladyship obtained yesterday, for which we're very grateful.
No, well, the person you should be grateful to is Mr. Dobbs, who's my judicial assistant, who sat yesterday and transcribed it on our behalf.
Well, then, thank you, Mr. Dobbs. So, my lady, yes, that is correct. And first thing I was going to correct.
Well, I'm grateful, Ms. Bangay. Thank you very much. There we are.
there's another, whilst we're on errors in notes, my lady, there is one other error in Miss Bangay and Mr. Wheel's note on page 6, paragraph 22.
Yes.
It said in the second line, towards the end of that line, at the hearing, wife applied for an unless order on materially identical terms to those in her current application. That application was dismissed. That is also incorrect. I have listened to, and of course, my lady and my lord can, if necessary, listen to the video recording of the exchange after Lord Justice Moylan gave his decision, in which Mr. Haggie applied for an unless order not in identical terms. The terms that he applied for was an order that if the husband did not pay the legal services payment order as directed by this court as well as Sir Jonathan Cohen, the appeal would be adjourned. That was the terms of the unless order that he applied for. That order was dismissed, although this court has subsequently, by my lady's order, adjourned that appeal. So those were the terms of the unless order that was applied for by Mr. Haggie, which appears on the order as having been dismissed, not the unless order about the dismissal of the appeal or Hadkinson.
Thank you. Good. Have we got ourselves straight then?
Thank you very much.
Yes.
Well, the lady, the position was in the Court of Appeal, as I indicated, as I think we've set out in our note, that my client had no hope of meeting a LASBO award, and we sought an application for a stay, which was dismissed by the court, which prompted the application by Mr. Haggie for an unless order. So, my lady, it was an application for an unless order. And
Well, you can make your submissions about that.
I understand
in due
that,
course.
but I just wanted to put the position before the court.
Thank you. Right.
The fundamental misunderstanding, so we say, in relation to the husband's opposition to this order, is that this court, or any court considering whether to make such an order, has to consider whether or not the payer can make the payment due under the order. And the reason it's a fundamental misunderstanding is because the authorities, which we'll turn to in due course, consider within the civil context whether or not to make an unless order. And as this court knows, within the civil court context, when making a cost order, it does not assess the ability of the payer to make the payment. So in that regard, if I can immediately turn to one of the authorities, that being the Bank of St. Petersburg, PJSC, and another, it's page 149 of the authorities bundle.
Thank you.
Sorry, give me the page again.
It begins at 149, and the page I'd like to take my lord to is page 156.
So tab 11.
I have a right. Can I just check which authorities bundle are we looking at here? Because I have two authorities bundles.
I'm so sorry, my lord. I've actually got a paper copy. It's the combined authorities bundle of the parties, and it's tab 11, as my lady observed.
I'm not sure I have. Okay.
It's a consolidate. The heading is consolidated list of authorities.
Okay. I have a very slim joint authority, something that says joint authorities bundle.
And that was replaced. I got mine this morning.
I apologise.
I thought I received an electronic copy, which doesn't have 149 pages in it.
May I read out? It's a very short.
Is this a decision of Mr. Justice Jacobs?
No, Mr. Justice Hilliard.
It's Hilliard. Okay. Well, it's not in the bundle for some reason that I have. Let me see if I can find another combined authorities bundle.
That's the one.
I do have it. Okay.
I'm very grateful.
We're good.
There are two authorities bundles I've got electronic.
I'm sorry.
Right, okay, I have it now. Yeah, got it.
It's page 156. It's a short point to the extent that it's necessary.
I should say that no criticism by either of us for any mistakes or errors or bundle issues. We're very conscious that we've put a lot of pressure on everyone to prepare for this short hearing at very short notice, and I think a very good job has been done. So please, nobody worry about any slip-ups. We'll no doubt make them, and we'll all make them together.
It's a short point, but it's important.
Paragraph
41.
Thank you.
So in the context of civil cases, the means of the party is not normally taken into account when making a costs order, whether interim or final, because it leads to satellite litigation in respect of an issue which is normally irrelevant in a civil case as to liability for an accident or commercial issue or whatever. So the reason it's important to draw the court's attention to that at this juncture is the authorities deciding whether to make an unless order in the context of a civil claim have not at that point considered the means of the payer to meet the order, and therefore whether it would be possible to meet the order, and then whether, considering Article 6 rights of the payer, it would be relevant and appropriate to make an unless order. So when one looks at the authorities in respect of the making of an unless order, one has to bear that in mind. So if my lady and my lord could turn to, within the authorities bundle, the case of Crystal decisions at page 117. Can I invite the court to read paragraphs 17 and 18? And that authority was picked up by Sir Richard Field in the case of Michael Wilson, which is the comprehensive analysis of this area of law. It's paragraph 23. It's on page 29 of the authorities bundle. And his lordship summarises the authorities there in paragraphs 23, 24 and 25. So, at paragraph 16 of Crystal, it's recorded that in any event to take the view that orders of the court, even in relation to interim costs, require to be complied with, and that unless there is some overwhelming consideration falling within Article 6 that failure that compels the court to take a different view, the normal consequences of a failure to comply with such an order is that the court, in order to protect its own procedure, should make compliance with that order a condition of the party in question being able to continue with the litigation.
Sorry, that was from Crystal.
Yes,
Paragraph 16.
yes, it's paragraph 23 of the judgment, referring back to Mr. Justice Patton in Crystal, at
Yep.
paragraph 16. And the decision of the court to assess the ability of the payer to meet an order of the court and making that a requirement for the continuation of the litigation is plainly appropriate and relevant and necessary. However, in the instant case, that question has already been answered. Ms. Bangay and Mr. Wheel refer you to the case of Quadro Commodities, page 48 of the authorities bundle, when considering the question of making a peremptory order against the defendant. And on page 49, Mr. Justice Jacobs considers whether such an order would preclude the defendant from being able to participate in the litigation if the peremptory order was made. And on page 52, paragraph 12, his lordship recalls that the application in that case was made against a defendant who's not currently trading, and there's no suggestion that he's a solvent party. So the question about whether or not to make an unless order or a peremptory order or a Hadkinson order necessarily involves consideration of whether or not the payer has the means to pay. Now, in this case, we're in a completely different territory because of the interrelationship between sections 22ZA of the Matrimonial Causes Act and 22ZB. And 22ZA, as this court knows, considers the whether or not a court should make an order in favour of an applicant when considering his or her ability to raise funds themselves. But importantly, 22ZB considers the ability of the payer to make the payment sought or considered to be ordered. And we set out in our skeleton argument on page 7 at paragraph 25 the considerations that the court has to bear in mind, take into account when considering whether to make an order under section 22ZA, and in the statute it records and makes it a requirement for the court specifically to consider under 22ZB the income, earning capacity, property and other financial resources which each of the applicant and the paying party has or is likely to have in the foreseeable future. It requires the court to take into account the effect of the order or variation on the paying party. And under subparagraph 3, the purposes of subsection 1H, i.e. the effect of the order on the paying party, the court must have regard to, in particular, whether the making or variation of the order is likely to cause undue hardship to the paying party or prevent the paying party from obtaining legal services for the purposes of these proceedings. So the issues that would normally come to be considered in a civil case for the assessment of whether or not someone has the means to comply with an order and therefore whether it would be in breach of their Article 6 rights or otherwise unfair to make a peremptory order or unless order doesn't apply in this case, because those are the matters which the court was required to assess in considering whether to make, and if so, to what extent, an order for legal services payment. And so we go back to this case, and the judgment of Sir Jonathan Cohen, I apologise, which is on page 88 of the bundle.
Which, you're going to have to be specific again.
Tab 12.
Sorry, my lord.
It's which bundle?
It's may I call it the appeal bundle
Yeah, or the core bundle.
or the core bundle?
That's the one you thought was coming hard copy.
Oh, right. That I thought was coming hard copy, which I've got electronically.
Tab 12.
Would my lord like a hard copy? We have a spare one.
Yes, I think I was promised one, but if
Thank you.
I think I have it.
Thank you very much.
Thought I had it electronically, but I can't open it at the moment. Just a second. Let me try again. Okay. Yeah, my electronic has failed, so I do have it electronically, but
Of course.
not opening at the moment for some reason.
Tab 12.
Excellent.
So we've got Sir Jonathan's judgment.
Thank you, my lady. So, paragraph 3, His Lordship considered the status of his finding in relation to the disputed accounts. And in paragraph 4, His Lordship considered that the husband had appealed that order and permission had been granted. And then considers the applicant's ability to fund her own legal costs, including Schneider's litigation loan at paragraph 7. I pause to say there for a moment that Miss Bangay's main argument appears to be that Forsters, my lay client solicitors, have continued to work for her. That concession was made in a letter which said that they would not work unless an LSPO was made, and it was made. This is about the enforcement, effectively, of the LSPO. They also gratuitously undertake Children Act matters for her as well. And it's not unreasonable for them to agree to continue acting that way, but they've made it clear they won't continue with respect to the appeal, and certainly counsel's fees and disbursements without an LSPO. That was made clear. But in any event, Mr. Justice Sir Jonathan Cohen made the order in my client's favour, and then went on to consider, having decided that it's appropriate to make an order, the ability of the husband to meet the payment of such an order. And on page 90 at paragraph 12...
Sorry, can I just wrap up on that
Yes.
point? The grounds of appeal from Sir Jonathan's order
Yes.
had a ground 2, which went to the wife's ability to fund future proceedings, and
Yes.
permission to appeal was refused
Yes.
on that. So the Sir Jonathan's finding stands.
Absolutely. It's unarguable before this court by Ms Bangay, any challenge to that. But just for completeness, because a loss is going to be made, I imagine subject to the court's willingness to entertain such submissions, that the it was wrongly made in some way because
The appeal was dismissed by Lord Justice Moylan and Lord Justice Zaccarelli and Lord Justice Stuart Smith last week. Or a week before.
20, yes. But turning to the 22ZA, the consideration about the husband's ability to pay and how that interrelates to the fairness of a peremptory order or an unless order, on paragraph 12 on page 90, His Lordship specifically turns to the ability of the respondent to pay the sums the court was being asked to order. And as my lady and my lord would have read from the transcripts that your judicial assistant kindly typed out, His Lordship took into account all of his findings, not just the question of the disputed accounts, and reference to that is specifically made by His Lordship at paragraph 13. Where His Lordship says the husband's always been able to fund his own legal fees for leading counsel. That he has at times found the funds to pay other disbursements, and reference was made in that hearing to, for example, his father, who has lent large sums of money to him. And so the court's conclusion at the end of that hearing was, firstly, that my client needed the order under 22ZA, which is not a finding which has been disturbed, and secondly, and importantly, under 22ZB, that the husband had the means to pay. Now, we know that the husband challenged that finding before this court, and the grounds of appeal on page 111 of the bundle, which is tab 15, thank you, my lady, was essentially recast by Lord Justice Moylan in the way he did in the judgment, that the reliance on the disputed accounts was improper or too great, and that the husband did not have the means to pay. That was the essential tenet of the appeal made by the husband. And as this court knows, that appeal was dismissed. So the court upheld Sir Jonathan Cohen's finding that the husband had the means to pay. On page 118, the order of this court following that appeal was that the husband had to pay the sum under paragraph 2 by Monday the 24th of April. So 4 days, 2 working days, 1 working day after the appeal. And Miss Bangay, on behalf of the husband, applied for a stay at the conclusion of that hearing of the order to pay the money, because she said to that court that my client would seek to enforce the order if it wasn't stayed, and this court refused that application, essentially saying it would be completely inconsistent with the dismissal of the appeal and the finding that Sir Jonathan Cohen was completely correct, that the husband had the means to pay and had not paid it, and so refused the stay of the order. All of those things lead this court, in our submission, to the inevitable conclusion that it is not open for the husband to say to this court that he does not have the means to pay. It was found by Sir Jonathan Cohen that he did on the 13th of December 2024. that finding was the subject of appeal and was dismissed on the 20th of February. So it simply does not lie in this gentleman's mouth to come to this court and to oppose the making of an unless order on the ground that he does not have the means to pay, or that this court should in some way investigate that question. And if one turns to paragraph 53 of the decision of Lord Justice Moylan, on page 9, I also do not consider that, as submitted by Miss Bangay, the judge's decision was circularly wrong because it placed wholesale reliance on his finding as to the £16 million. Sorry, I'm so sorry.
No, I had the judgment loose. I found it. Paragraph
53.
Thank you.
The judge did not place... Sorry, my lady. The judge did not place wholesale or sole reliance on this finding. He referred more than once to his findings, plural I emphasise, which included other matters to which I have referred. As to his challenged finding, the judge did no more than, as he said at paragraph 14, take this into account. Further, in my view, the judge had to consider, in accordance with, among other matters, the overriding objective and the balance of justice or injustice, or the balance of prejudice, when deciding what order to make. This included deciding what weight could properly be put on the challenged finding and the other matters relied on by the parties. So many of the factors that this court has to consider were already considered and had been considered by Sir Jonathan Cohen. The balance of justice, the need for my client to receive money in order to resist the appeal brought by the husband and the bank, because Sir Jonathan Cohen rightly considered both were together in relation to the necessity for my client to have funds. And the decision of both Sir Jonathan Cohen and the Court of Appeal in dismissing the appeal assessed all of the matters that this court is being asked to consider by my client's application, save for the question of the sanction for breach of Sir Jonathan's order and this court's order. Having decided that he had the means to pay, and that appeal having been refused by the court, and a stay being opposed, the question of the unless order is simply the court's ability to ensure that its own orders are implemented. Without it, as Sir Jonathan Cohen found, the injustice that will be caused to my client would be intolerable. At page 56 of this court's decision, when dismissing the appeal, Lord Justice Moylan said, the judge had therefore to consider the balance of prejudice when deciding what weight could fairly be applied to the challenged finding. In this case, the judge was plainly entitled to decide that it would cause the wife a grave injustice if he was to permit the husband and IIB to be represented, but the wife not. And that finding by Sir Jonathan Cohen, endorsed, if I may refer to it in that way, by this court, underpins fundamentally our application for an unless order. This court has adjourned the appeal. We would be in an odd situation if this court, having made an order that the husband pays, then fails to pay, relists the appeal, which is then subject to another application to adjourn on the basis that he hasn't complied with the order of this court and the findings made. I want to Alice in Wonderland, but that's what it would amount to. And so I'll obviously reply as necessary to any submissions by Ms Bangay, but in relation to the question of the unless order, given the findings of Sir Jonathan Cohen and this court, night follows day, that is the appropriate order. It doesn't interfere with the husband's Article 6 rights because the court has already found that he has the means to pay. It's a reasonable and proportionate order because without the order being made, his own appeal cannot go ahead. My client, her solicitors, have said very clearly they will not fund an appeal. The suggestion that my client should go out and find some pro bono counsel is an attack on the 22ZA finding that my client reasonably needs legal fees funding, which has been refused by the Court of Appeal to entertain. It's a collateral attack on that decision. Of course, this court has, it's a discretionary remedy, but in our submission, it cannot be the case that the husband's appeal remains alive in circumstances where he is in breach of an order, and this court ordered him to pay it within 4 days. And as we see from the decision of my lady in C&C, which is in the bundle behind tab 10.
Tab 2?
Sorry, tab 2, I'm so sorry.
Thank you.
In the context of a Hadkinson application. The court considered at paragraph 25 the Mubarak decision, is the husband in contempt? Clearly, yes. Is there an impediment to the course of justice? Yes.
So where are you?
Sorry, I'm so sorry, paragraph 28, it's page 16.
Yeah, you said, I think you said 25.
I'm
said
so
25,
sorry.
sorry.
My
Got
mistake.
there.
Yep.
So are you moving on to Hadkinson now?
There's an overlap, and I'm going to deal in a moment between the difference between the two types of orders, if I may. But there's obviously a significant crossover between the two,
Of course.
but they're not coterminous.
Exactly.
Is the husband in contempt? Yes. Is there an impediment to the course of justice? Yes. Is there any other effective means of securing compliance with the court's orders? No. Should the court exercise its discretion to impose jurisdictions having regard to the questions? Yes. Is the contempt willful? Yes. If so, what conditions would be proportionate? And it goes without saying that the questions of someone's resources is not confined to the money in their own bank account. Section 25 makes that clear. The husband has the resources of the bank, who apparently has spent £200,000 since the trial. They lent him, as we put in our note, £3.48 million to extend the lease on the family home by way of a bonus. He has borrowed £400,000 from his father for Children Act proceedings, amongst others. But I return to the findings made by Sir Jonathan Cohen, upheld by this court. So I'd like to move on, if I may, unless there's any matters you wish to ask me about in relation to that, the difference between unless orders and Hadkinson in our submission. Clearly there is a significant overlap between the two. Our central submission in relation to this is that an unless order is simply one order within the court's armoury. It is not a matter of last resort, as has been said in relation to Hadkinson orders. It is one which is directed to the proper administration of justice and upholding the court's orders. and peremptory orders within the civil context, and in relation to this case, the same, are to ensure that its own orders are carried into effect. Now, within that context, as I mentioned right at the beginning, the court would have to consider, in a civil context, the ability of the payer to pay, which the court's already done in this case. And so it's simply one of the remedies available to the court to ensure compliance. Hadkinson is a much broader jurisdiction. The court's orders under an application being made for a Hadkinson order are much wider. They can prevent, for example, an application being made, a prospective application to be made. It can limit the extent to which someone can defend an application that has been made. It is a much broader jurisdiction. The simple application we make is for an unless order, but the court could make it under Hadkinson also, based on the Mubarak grounds and those found by my lady when sitting in the High Court of First Instance in CNC. That was obviously upheld in De Forge. I won't take you to the passage, but it's for the court's note on page 46, paragraph 16. It reiterates these factors. But the essential submission is that this is clear unless order territory. It could be made under Hadkinson as well. And the decision in the Forge is very much on all fours with this case. But I return to our central argument, which is, if the husband does not pay, what happens to his appeal? His appeal of the order having been dismissed by this court, the stay refused, and the order made. I don't know whether my lady, my lord, would like me to develop anything else in relation to the Hadkinson and the unless order applications at the moment, and whether you wish to hear from Miss Bangay in response to those before dealing with other matters, or whether you wish me to, of course.
Are you intending to deal with the companies separately?
Well, yes. I mean, the application that my client makes is for an unless order and Hadkinson in relation to the husband.
Yes.
There's no application before the court for the same orders in relation to the bank.
Right.
However, we make it plain in our note that that may be an application that we make in the future against the bank.
Yeah, well, the present position is that they're not in contempt.
They're not in contempt. And there's a number of different pathways that this appeal could take. So one is that the husband, if the court is with us in relation to the application for an unless order, the husband could pay, comply with what the court has told him to do on numerous occasions.
Yeah.
In which case, the wife will be in funds to defend the appeal from the husband as well as the bank. If the husband does not pay and chooses not to comply and his appeal is struck out, then there is a question about the overlap between his appeal and the bank's. His appeal will have been dismissed and gone away. There will be a finding that he has £6 million
Yep.
or the ability to pay my client £6 million. And the question of the bank's position will then be potentially a matter for reconsideration at first instance, because, and this is why I raise at the beginning of our submissions the question of the nuptial settlement. The bank's concession, first of all, that it could extend the terms of the forward acquisition property purchase agreement, was a significant development in the case, because up until that point, their position had been the FAP has expired, the bank is entitled to enforce it, and it wants the property back. And what happened during the hearing was that the bank, Mr. Hussein giving evidence on behalf of the bank, said, well, we could consider extending it. and then subsequently through Mr. Richardson, as my lord knows, agreed that the bank would extend funds to my client to purchase property to be on measure terms.
Yep.
Now, that calls into question the extent of any nuptial settlement under Ben Hashem and the other authorities, or more importantly, the question of the extent to which my client can remain in the property until the husband has satisfied the judgment that the court has made in relation to the payment of money, because obviously she'll be without housing unless and until the payment has been made. So there are a number of different questions because of the husband's position as the 60% shareholder in the bank and the CEO of the bank, which can decide, subject to proper corporate governance apparently, the extent to which the bank would extend the terms of the occupation by the wife in the property, so long as that judgment of the CEO of the bank remains unpaid. So we don't press that application at the moment, but we advertise the complexities of the situation if it turns out that the husband's appeal is dismissed because of the...
But we still have the outstanding appeal,
Yes,
for which permission was granted.
yes, absolutely. So in that regard, our submission is that the court should adjourn both appeals, that the unless order should be made against the husband, if the unless order bites, as it were, the sanction imposed by the unless order comes to pass, the wife will have to consider in communication with the bank whether, for example, the concession she made at the beginning of the trial, not knowing that the FAT was extendable, not knowing that the bank was willing to offer my client occupation on until tertiary education, means that she's to resurrect her application for a variation.
Still got the appeal.
Absolutely, absolutely. And so it may be by way of a respondent's notice, it may be by way of...
What are you asking us to do in terms of relisting the bank's appeal?
Nothing, apart from relisting it in enough time so that the unless order sanction comes to pass. The wife will then have to consider what applications she makes in relation to the bank's appeal.
How long after the sanction in the unless order that you want do you say that the bank's appeal should be relisted?
Well, both appeals should be relisted.
Sorry.
What?
No, if the less order's
so-
bitten.
The order that the court could make today is to relist both appeals. One might fall away because of the imposition of the sanction imposed by the
All right,
unless order.
I think what my lord...
I'm so sorry if I misunderstand.
No, I think what my Lord Justice Snowden is asking is, in the event that an unless stroke Hadkinson order is made, and in the event that the husband, notwithstanding that, still does not pay, and so his appeal falls away
Yes.
automatically, what do we do about the outstanding appeal of the company who's been given permission to appeal and who is not in contempt?
Yes. Well, the wife will... I'm not asking the court to do anything today.
No,
in
but
that
we.
regard.
But is your submission that it should be relisted the week after the unless order is bitten,
No.
or the month after, or the year after, or
We would submit that 2 months would be an appropriate time
after
the unless order bites. Because, and I advertise it now, it's not something which we are saying will happen, but it's something that we are considering, which is an application for a variation of the postnuptial settlement.
That's a matter entirely for you.
Of
What
course.
we're concerned with
Is timing and relisting.
is the issues before us.
Of course, because it may be the case that if that application is made, this court might say that the hearing of the bank's appeal might await the decision.
Well, that would be a different application.
Of course
which-
it would be.
for
Of
another
course.
day.
Absolutely.
I mean, all sorts of things could happen. I mean, if the husband's appeal evaporates, disappears, then all sorts of actions
Absolutely.
may follow. And I'm not
Transfer
going to
of property for
speculate.
shares, a whole manner of...
Receivership, all sorts.
Of course, exactly.
That's nothing to do with us, and we won't be taking any of that into consideration when we are deciding the very tight, discrete issues that are before us.
Of course, my lady. But that would be sufficient time after the imposition of any sanction comes to pass, for the wife to take sufficient receive advice, give instructions, make any applications, so that we don't have a situation where, for example, the bank's brief fees are deemed in circumstances where the wife is making an application which might cause the appeal to be postponed.
Well, we have your submission that the bank's appeal should be relisted
At least 2 months.
2 months after.
And you say to allow for the possibility that the unless order, if it's an unless order, the Hadkinson order is actually complied with, the order you technically say ought to be done is that both appeals are adjourned to the same point in time.
Yes.
But with a sort of period of time, what I call a sanction period.
Yes.
And then 2 months.
Yes. Because, and I make this plain that if, for example, we do make an application before family court,
it doesn't, in a sense, it doesn't matter what you might or might not
of course.
do. You just need a period of time within which to either decide to do it or not.
And sufficiency of briefs aren't deemed.
Well, you never know. People could start talking to each other.
What? Quite.
Astonishing.
Yeah, absolutely.
Yep.
I'm not going to deal with the question of cost, which is a third thing that my lady asked.
Not at the moment.
At the moment. But is there anything else before I turn my back that you?
Well, not at the moment.
No. Yeah. No,
Thank you, my lady.
Miss
Thank you,
Daisy.
my lord.
No, Miss Bangay.
Lady, I don't underestimate the task on behalf of my client in standing here today opposing a Hadkinson order or an unless order.
Very realistic, if I may say so, Miss Bangay.
Well, lady, I would be a fool to do so. My lady, may I just make a few preliminary observations just to give these applications some context? Lady, the whole approach of the wife to both the substantive proceedings and subsequently has been one of vilification of my client. And, my lady, what the court should not forget is that this is not a man who has flouted any orders of the court. This is not a man who has flouted the maintenance order that was made by Sir Jonathan Cohen. All he has done since Sir Jonathan Cohen gave judgment is exercise his right to appeal his judgment, and in particular the finding on his finding that my client is the owner, in effect, of the disputed accounts containing some £16 million. And indeed, as your ladyship and your lordship knows, my client was given permission to appeal that finding.
Albeit somewhat tentative, the wording used by Lord
The
Justice
lady,
Moylan.
tentatively, but he was given permission.
Understood.
He could have been refused
You could indeed.
permission. So he exercised his right,
Absolutely.
permission was granted. So all he has done is legitimately exercise that right. And all the wife has sought to do since is to vilify him for pursuing that appeal. And at the same time as dealing with the appeal and all the applications that have come our way in the last year, my client is the CEO of a bank and he has had to carry on working under significant pressure. And it's right just to set the appeal and the current applications in context. And, lady, mindful of the perhaps sceptical approach that this court would adopt today in respect of his opposition to the Hadkinson and unless orders, he has nonetheless volunteered a full statement, which I hope your ladyship and your lordship have seen, which sets out his up-to-date current financial position.
Miss Bangay, you can't rely on any of that.
I'm so sorry?
You can't rely on any of that.
Well-
Lord Justice Moylan refused permission. Dismissed the appeal against the legal services.
Lady, when I come to the Hadkinson, lady, I say that, which I will come to in a moment, I would be saying that his non-payment of the LSP award is not deliberate. and that this court is bound to take into account his current financial circumstances and whether or not he has the means to pay.
But his current financial circumstances are against all of the findings made by Sir Jonathan Cohen, not just in relation to the bank accounts that he has got permission to keep.
Well, can we just remind ourselves of the findings that Sir Jonathan Cohen made? The award of £6 million was foursquare based on a finding of the existence of the disputed accounts. There was no suggestion that there was any liquidity in respect of my client's bank shares. There was no suggestion that the Mr. Akbar arrangement was going to come to fruition any time before 2031. That was the only source of liquid funds. And apart from that, he has an income. And he has an income of $425,000 a year, which translates roughly to £350,000. And your ladyship knows that that is spoken for is maintaining two families. So when your ladyship says, well, he made the order on the basis of all his findings, it was foursquare on the basis of the 16 million account. And I can take your ladyship to the judgment if need be. If your ladyship will find it's in the bundle. At page 21. I've wrestled with this issue, the hardest in the case. Are the letters part of the
Sorry, could you?
presentation
I'm sorry. Would you mind giving?
I'm so sorry. Paragraph
I'm
104.
working from my separate one. So if you
Right,
paragraph
it's
numbers.
104.
104. Thank you. Yep.
I've wrestled with this issue, the hardest in the case. Are the letters a part of the presentation by the husband IIB to others of being a man of entity or substance to present an exaggerated picture of wealth, or are they the truth? I look at the totality of the evidence, including that of the accountants, and ask myself what is the most probable explanation. Have two highly qualified individuals written letters setting out the truth, or have they written out letters, have they written what are deceptive and dishonest letters? In either event, they admit that they then wrote statements verified by statements of truth they were untrue. The repeated lies about these letters, together with the factors set out at paragraph 94 above, persuade me that they are more likely to be true than false. If I am in error, the husband has only himself to blame. I do not know where the money came from or where it is now, but that there is some of it left is at least probable. And then he summarises the assets in the case at paragraph 141. So 143, I'm not going to read the passages out, I'm just going to refer you to them. And then liquidity, 144. The SJE advised there's no significant liquidity within IIB, so as to enable a payment to be made out to the husband either for his benefit or that of the wife, subject to the advisor that the wife doesn't accept the husband's disclosed the money referred to in the 2020 letters. She doesn't challenge the conclusions of the SJE. And then he sets out at paragraph 147 the assets, and they are the property in Portugal, the savings as he found them to be of £16 million, his illiquid interest in IIB, the debt owed by Mr. Akbar, which you know doesn't come into play until 2031, and the wife's liabilities, and then the husband owing his father £465,000. So there were no other assets which Sir Jonathan Cohen found were available to the husband to fund the award other than the disputed accounts. And in his skeleton argument, and I don't know whether you're going to give credence to this, that Mr. Glazer makes what we say is a number of factually inaccurate assertions. And can I just be clear on the basis on which my client appealed? And that's set out, obviously, in his grounds appeal. I don't know if your ladyship will have an opportunity to read them. Your ladyship will see there were two grounds. One was the procedural unfairness. And we say that having never pleaded a case that the husband was guilty of material non-disclosure and positively asserting at the outset of the trial that they were not suggesting there were hidden bank accounts, nor was it suggested to my client in cross-examination, contrary to Mr. Glazer's note, that the bank account existed. Because during the cross-examination, what Mr. Glazer asserted was that the letter was a sham. It was never put to my client that account...
But these are all matters for the appeal if it takes place.
I understand, but these are assertions made by Mr. Glazer in his note, and I just wanted to correct them. Maybe they don't come into play in your ladyship's mind today.
They really don't.
They really don't, and then I will move on. And, lady, the thrust of Mr. Glazer's submissions that there is really not much to choose between an unless order and a Hodkinson order. And that on the basis, he says, of the authorities, if someone doesn't pay a cost order, then day follows its night, that they should not be able to pursue whatever litigation is relevant in any particular case. And lady, he took you to a number of authorities, and I would like to take your ladyship to those authorities because Mr. Glazer didn't, I don't think, give you a complete picture in terms of what those authorities say.
Certainly.
Can I first take you, please, to the day's healthcare?
Now, we didn't look at this with Mr. Glazer, did we?
No, you didn't look at this, and I just want to take your...
No, certainly.
It's the first tab.
Thank you.
And paragraph 6. So that remains the position today. It's page 4 of the bundle, paragraph 6. Nothing has been paid, nor is it a case of want of means. The defendants have the means, but refuse to pay. They choose not to pay and challenge not just days, but the court to make them do so. And then it goes on. And so, lady, that was an entirely different situation from the situation that prevails.
In what respect? Given that the courts have found that your lay client has got the means to pay.
Well, lady, the difficulty is, for me standing here, is that my client has permission to appeal a finding that he has or is able to pay a lump sum of 6 million. He has permission to appeal that finding, and he has put in an application for fresh evidence, which evidence comprises of auditors' reports, which show beyond doubt that those accounts never existed. And that is my difficulty, lady. I can't run that appeal before you today, but what I can say to you, ladyship, that is what my client's case is.
I understood.
And so, from my client's perspective, if not necessarily at the moment from the court's perspective, he does not have the means to pay this award. The wife is not able to point to any other liquid source of capital which is available to my client to pay such an award. All he has is his income and very substantial debt, as I know the court is aware, to his solicitors and in fact to his dignity. And that debt is well over £1 million and has increased, not reduced, since trial.
Why have his lawyers allowed him to run up that level of credit? They must have some assurance or some expectation of
Well,
being paid.
as
Otherwise, they're just mad.
well, as Ms. Masawi, or as we explained to Sir Jonathan Cohen, and as I repeated to the Court of Appeal, Ms. Masawi has acted for Mr. Sultan for many, many years. He has referred work to her, and he has assured her that at some point in the future, and he can't say when, he will discharge his fees, outstanding fees to her. And on that basis, she has been prepared to continue to act for him, albeit on a shoestring basis. Because as your Lordship will see from the cost schedule cost summary that we produced, that we have spent.
But it's. I mean, I suspect you're giving evidence to that effect on your feet, are you? I mean,
No, this is what was included in my client's affidavit before Sir Jonathan Cohen, and it's what I repeated to the Court of Appeal. And Lord, as far as myself and Mr. Will appears here pro bono, and I have made it clear to Sir Jonathan Cohen and the Court of Appeal that I will not abandon my client on this appeal because the issue is so grave for him and the consequences potentially catastrophic. So that, I hope that answers your Lordship's question. This isn't a situation where we know we're going to get paid around the corner, because there is nothing that suggests to Ms. Masawi that the payment of her fees are imminent or even foreseeable in the short to medium term.
Well, maybe foreseeable if the plan re the bank's future comes to fruition in the medium term.
Well, depends what you determine.
Well,
Certainly not
grown
in the
for
short term.
It said in
medium
papers,
to longer term.
It said in the papers it's being grown for sale.
Yes.
So given the age of everyone involved, one would hope for their sake it's medium, not long term.
But is there a payment on the horizon, my lord? No. Will his legal team abandon him, bearing in mind the seriousness of the issue? No. And that is why we are standing here today.
Thank you.
May I then take your Lordship to the case of Michael Wilson, which is tab 3 of the bundle. And in that case, the litigant had failed to pay various cost orders totalling 1.2 million. If we go to paragraph 29, please, of that judgment. Actually, if we can, sorry, page 29, and read from paragraph 23. The first references to crystal decisions, which Mr. Glazer took the Lordship and your Ladyship to. And it says, if the rules of the court under the CPR do not prescribe any particular procedural conditions which have to be satisfied in an application of this kind, the consequences of a failure to comply with an order for costs made during the course of action in relation to the future conduct of the action is therefore a matter to be dealt with as part of the inherent jurisdiction of the court. It's perfectly true, of course, that parties in the position of the claimants would, in these circumstances, have other remedies available to them. Those might include proceedings for contempt, but equally they might involve a more routine enforcement of the judgment for costs by, for example, seeking an order for payment and a charging order against any known assets. In the present circumstances, however, where they are faced with defendants who are not resident within the jurisdiction and have no assets here, those remedies are likely to be of limited value. In any event, I take the view that orders of the court, even in relation to interim costs, require to be complied with, and unless there is some overwhelming consideration falling within Article 6 that compels the court to take a different view, the normal circumstances of a failure to comply with such an order is that the court, in order to protect its own procedure, should make compliance with that order a condition of the party in question being able to continue with the litigation. And then it goes on in dismissing Vavitech Corp's application for permission to appeal the unless order granted by Mr. Justice pattern was, but thirdly, to my mind, most importantly, the court's ability to make interlocutory cost orders following particularly the access to justice reforms in 1998 is a sanction which is available to it in order to encourage responsible litigation. The court marks what it regards as an irresponsible application by an immediate order for the payment of costs. It is intended to bring home to a party, when considering whether to make an application, that an unsuccessful application may carry a price which will have to be paid at once. If the court's not in a position to enforce immediate interlocutory orders for the payment of costs, which I thought it was right to make, then the force of that sanction is seriously undermined. It is important in cases where the court thinks it's right to make an order for payment on the interlocutory application that it does have the power and can exercise the power to ensure the power is met. The reasons which Justice Patton explained, the only effective sanction in a case of this nature is to require payment of interlocutory costs as the price of being allowed to contest the proceedings. Unless the party against whom an order for costs is prepared to or can be compelled to comply with that order, that the order might just as well not be made. And then it goes on in terms of paragraph 16 of the judgment. For my part, I would hold whether or not a statement in general terms can be supported, the proposition can be supported in a case such as the present, where there is no other effective way of ensuring the interim cost order is satisfied. That, of course, is always subject to what the judge referred to as the overwhelming consideration within Article 6, that orders requiring payment of costs as a condition for proceeding with litigation are not made in circumstances where to enforce such an order would drive a party from access to justice. And that really is rather the point that I'm seeking to make today. But for the reasons the judge explained, to which I've already referred, this was not such a case. And then paragraph 26 refers to Mutual Systems and the Crystal judgment, and goes on, I derive the following principles as being applicable to the case before me. The matter is always one for the court's discretion, and all relevant circumstances fall to be considered. If the court is not in a position to enforce interlocutory cost orders, the force of the sanction is seriously undermined. Other options apart from the order must be considered, but it is always important to have regard to Article 6. Orders requiring payment of costs as a condition of proceeding litigation are not made in circumstances where to enforce such an order would drive a party from access to justice. And then further down on the page, paragraph 29, in my judgment, the following principles are applicable when dealing with an application. The party to ongoing litigation should be debarred from continuing to participate in litigation by reason of having failed to pay an order for costs made in the course of the proceedings. 1. The imposition of a sanction for non-payment of a cost order involves the exercise of a discretion pursuant to the court's inherent jurisdiction. The court should keep carefully in mind the policy behind the imposition of cost orders made payable within a specified period of time for the end of the litigation, namely that they serve to discourage irresponsible interlocutory applications or resistance to successful interlocutory applications. And then 3, consideration must be given to all relevant circumstances. The potential applicability of Article 6, the availability of alternative means of enforcing the cost order through the different mechanisms of execution. C, whether the court making the cost order did so notwithstanding a submission that it was inappropriate to make a costs order payable for the conclusion of the proceedings in question, and where no such submission was made, whether it ought to have been made or there was no good reason for it not having been made. And then critically, paragraph 4, a submission by the party in default that he lacks the means to pay, and that therefore a debarring order would be a denial of justice and or breach of Article 6, should be supported by detailed, cogent and proper evidence which gives full and frank disclosure of the witness's financial position, including his or her prospects of raising the necessary funds, where his or her cash resources are insufficient to meet liability. My lord, that addresses your point that I think you said, well, we can't take into account your client's latest affidavit. Lady, we had that passage very much in mind when my client prepared the statement in haste, as he did for this hearing at short notice. And then 5, where the defaulting party appears to have no or markedly insufficient asset in the jurisdiction, has not produced proper and sufficient evidence of impecuniosity, the court ought generally to require payment of the cost order as the price being allowed to contest the proceedings. And then 6, if the court decides a debarring order should be made, the order ought to be an unless order, except where there are strong reasons for imposing an immediate order. So I take issue with Mr. Glazer's submission to this court, that this court is in effect debarred considering my client's financial position, and that the findings of Sir Jonathan Cohen and the findings of the Court of Appeal thus debar this court. This is a separate and distinct decision which this court has to make in accordance with the principles we say set out at paragraph 29. And that involves, lady, considering the detailed, cogent and proper evidence which we say is contained in my client's statement.
While we're just on the statement, but before we go to other bits of it, can I just go back to the answer you gave me a little earlier, where you said that your solicitor and yourselves are not prepared to abandon
Yes.
your client. Can you just look at paragraph 23 of the statement?
Paragraph 20 of my client's statement.
Yes. The one that I think you're referring to.
Where is it?
It begins, I continue to litigate. Is that right?
Yes. Can I just focus on that for a moment?
I've got it in a separate bundle that I was that was filed and I downloaded.
Do you have a hard copy of it, Sophia? Does anyone have a hard copy?
I mean, I do. I'm just a matter of digging it out again. Where's the parent submission? Witness statement. I have it. I have read it.
Yes,
actually.
I'm familiar with that now, my lord. Thank you.
Yes.
Paragraph 23.
It's paragraph 23, which the first bit of it I think corresponds to what you said about the relationship, long-standing relationship between your client and your lay client and solicitor. It's the bit that appears in the middle of paragraph 23. Am I misreading this? She, that is the solicitor, has made it clear to me that even if I were able to raise funds, which I cannot, to meet an LSPO order for Myrna and or to meet the costs order made against me, she, that's the solicitor, would not be prepared to continue to act carrying the level of debt she carries when I am applying funds towards Myrna's representation. Is that saying that if your client could raise funds and use the funds to comply with court orders, the reaction of the solicitor would be to abandon him?
Neville, what
isn't that what that says?
What Miss Masawi's position is that she...
Yeah, but what does that... have I misread that?
You haven't misread it.
I have not misread it.
My lord, no. But what can I just explain a little further?
Right.
Because I've asked Miss Masawi, who sits here, precisely what was meant by that. And what she said is that she has taken a view on the fees that are outstanding, and she has not received, as your lordship knows, a penny since the October 23 trial towards her outstanding costs. And she would feel it inappropriate if my client could raise funds that he didn't seek to discharge some of the monies that were owing to her and have been owing to her now for well over 18 months.
So she would... So her reaction to your lay client complying with court orders to fund, amongst other things, Mina's representation would be to abandon him.
Well, I think that's putting it a little harshly.
Well, okay.
What Miss Masawi instructs...
I won't use the word abandon. I will just simply say cease to act for him.
Well, what Miss Masawi instructs me is that she is continuing to act on my client's assurance that any sums that he might raise would first go to her. that is the basis on which she has continued to act for him. And I think what your lordship is putting is that, for example, if he were to raise £100,000 somehow, that he would pay that to her first, then that would, but it's a hypothetical question because he doesn't have any ability now or in the foreseeable
Well,
short
save
to
and
medium.
except paragraph 23 was written and filed in this court for today's hearing.
I understand that. That's honestly recording a discussion which they have had.
I'm not criticising the honesty, on the contrary, it's admirable.
Yes.
But we're just trying to work through the consequences of that.
Yes, what Miss Masawi has taken a view, and you might think, and I might think, a very generous view, as not to, as it were, cut her client loose because he owes her over £600,000. In fact, now it's closer to
I thought the figure was 800,000.
But she would feel, if I can use the colloquialism, hard done by if he were to be able to raise funds and they didn't first go to her because she has been distinctly forbearing.
Well, her position's clear, thank you.
So may I go back to the authorities and we'll come to my client's statement in a moment. Would you just forgive me?
Of course.
Well, I have clarity on my instructions at least. Can I just read what my instructions are? Miss Masawi would not be prepared to continue to act if he were to pay the wife or Forsters and not her, for the reasons that I've given the court.
Thank you.
May I take you now to the back to the authorities bundle and to Quadra, which is Quadra Commodities at tab 5. It's paragraph 11. Is your ladyship there? Not quite.
Nearly. Thank you.
It's also relevant, in my view, that the only basis on which it is said the defendant should be debarred from participating in that hearing is that the costs of £100,000 have not been paid. This is not a case where it is alleged, that at least subsequent to the orders made by His Honour Judge Telling, that there has been other contumacious conduct on behalf of the defendant. The anti-suit injunction was designed to bring an end to the Russian proceedings, and it seemed the Russian proceedings are indeed not currently being pursued by the defendant. The anti-suit injunction was also designed to ensure the parties' disputes were resolved in London arbitration, and that is indeed what is happening. Both parties have served, as I understand it, submissions in the context of the London arbitration, where there's been a considerable amount of interlocutory activity, which is not necessary to describe at present. So the present application was based solely on the non-payment of costs, and that is one feature of the case which distinguishes, at least on the facts, from the principal decision relied on by Mr. Kershid, namely the Day's healthcare case, which I'll come to in a moment. And then if we go on, please, to paragraph 19.
Well, we need to look at 12.
Yes, the unusual feature of this present application takes place against the background defendant who is not currently trading, where there is no suggestion that the defendant is a solvent party and well able to instantly pay whatever debts it may have. On the contrary, the defendant is in liquidation and subject to bankruptcy proceedings. Indeed, the issue in the case, as I recall it, is that they had advice under Russian law that they could not make the payment, otherwise they'd be subject to criminal sanction in Russia. And if we go on to paragraph 19, that's explained, I think, at the bottom, paragraph 17, in fact. And then if we go on to paragraph 19, I do not consider this correct. So clearly, if the argument put forward by the defendant's experts was fanciful and could be rejected very clearly and easily by the court, then it should indeed be disregarded. But I do not consider, and I cannot come to that conclusion on the present material. So that is where the court was provided with conflicting experts' report, and it decided to follow the Russian expert who said if the payment was made, it could potentially have criminal proceedings. And then paragraph 26, sorry, paragraph 24, it refers to the political principles in the case of days. And then paragraph 25, those cases indicate that it's possible to make an order against a party, such as defendant in the present case, which would in practice then effect a fine for participating in further proceedings if costs are not paid in accordance with the prior court order. The Motorola case indicates the court should exercise a degree of care before debarring someone from making submissions, even where that person is in contempt. That is particularly so where the order is sought against a defendant who's taking essentially a defensive position in litigation. Accordingly, a debarring sanction is by no means automatic where costs are unpaid. Paragraph 26, in Day's Healthcare itself, where the judge was persuaded to make an order, the facts were extreme. The defaulting defendant was clearly solvent party who was in a position to pay and was taking every possible step to frustrate various orders which the court had made. The proposed hearing, which was a detailed assessment of costs in which he wished to participate, was anticipated to last many days, and every single point was being taken within that assessment in order to frustrate orders of the court. There was no or very little prospect of voluntary payment by the defaulting defendant at the end of that detailed assessment. And so it does urge the court to be cautious. And then we have Gold Trail, and it's it's paragraph 16. Forgive me, paragraph 14. And it's page 135 if you're working from a bundle. It's paragraph 14, and it goes on paragraph 15. There is no doubt, indeed it is agreed, that if the proposed condition is otherwise appropriate, the objection that it would stifle continuation of appeal represents a contention which needs to be established by the appellant, and indeed, although it's hypothetical, to be established on the balance of probabilities. For the respondent to the appeal can hardly be expected to establish matters relating to the reality of the appellant's financial situation, of which he probably knows little. But for all practical purposes, the courts could proceed on the basis that were it to be established that it would probably stifle the appeal, the condition should not be imposed.
Can you read on? Ask me in French to read the next paragraph.
Certainly. Do you want us to read it to ourselves?
Why not?
Thank you.
I think the point Mr. Glaze is getting at is at paragraph 18, when he suggested, essentially, I suppose my client is going to say could raise monies from the bank, but paragraph 18 urges great caution.
Understood. Thank you.
And so, in respect of an unless order, the court is bound to have to consider, one, whether the imposition order would stifle an appeal. And as I've taken the court to the fact that my client has permission to appeal, that it is in principle considered there's a prospect of success. And secondly, the court is bound to take into account his ability to pay. And that is beyond the decisions both of Sir Jonathan Cohen and the Court of Appeal, because this is a separate and distinct discretion that this court is exercising. So may I now turn to the Hankinson jurisdiction?
Certainly. Yes.
When you say that we have to consider your client's ability to pay afresh, I suppose you say.
Absolutely, that's the whole point. That's the whole thrust of the authorities.
What weight are we either entitled to give, or do we have to give to previous findings of judges that have been made between the parties?
My lord, the cases that we've looked at, none of them are what I would call within the matrimonial jurisdiction. And therefore, the guidance given in those cases is relatively limited on less orders. When it comes to considering his ability to pay, I think the court can take into account the statement that he provided to the court back in December 2023, which set out then his income and his liabilities, and the statement that he has made for the purpose of today really shows the position hasn't changed.
Do you say what? We just start afresh with any piece of evidence that's out there, and we've got to go through it all?
Well, I think I would be pushing at a closed door if I suggested that you shouldn't have an eye to the evidence that hasn't been previously before the court. But the court needs today to see what is his financial position and what is his ability to pay.
You do need to get permission to file the witness statement.
Well, lady, the authority seems to suggest that we must file cogent evidence. We have filed that evidence, and so, bearing in mind the authorities, I would ask for the court for permission to file that statement.
My question wasn't actually about the statement. My question was actually about the attention, weight, or otherwise, which we give to previous judicial findings, which are binding between the parties to this litigation.
Well, can we separate out two different types of findings? One is the findings on the accounts. One is the findings as to my client's other assets. In terms of the findings in respect of the accounts, that is legitimately, we say, under appeal.
The disputed accounts.
It's the disputed accounts.
Subject to appeal, yeah.
And so we say that the court would be wrong, bearing in mind that it's subject to an appeal to...
But the point made against you is that there's a binding judicial finding that your client would be able to pay.
No, it's based on the disputed accounts, my lord. That was the decision of Sir Jonathan Cohen, both at the substantive hearing and also at the LSPO hearing last year. That was the primary basis on which he said that my client could pay any monies, because there is no evidence, there was no findings that he had any other liquid funds or any other source of borrowing. There was no finding to that effect in either judgment. That is why Sir Jonathan Cohen was driven to the finding of the disputed accounts. But I'm not here to litigate the issue of the disputed accounts today.
So you say it all leads back to a finding under appeal?
Absolutely, because there was no finding in December. Mr. Haggie put all sorts of arguments before Sir Jonathan Cohen in terms of how we might raise funds. And Sir Jonathan Cohen, can we just go to his judgment? Court bundle.
So you, I mean, the difficulty I've got with this is that appears to be the submission that you made, which was rejected by Lord Justice Moylan in paragraph 53 of his judgment last week.
No, what Mr. Justice Moylan said that the judge was entitled to take into account all his findings when he came to the decision that he did. But if one goes back to the judgment one can see those findings are referred to paragraph 3.
So which where?
Paragraph 3, forgive me, page 89 of the core bundle. There's a sort of element of unreality about this hearing, that passage.
Sorry, we're talking about Moylan LJs.
No, I'm going back to Mr. Jonathan
just-
Cohen's findings. Page 89 of the core bundle, my
Just
lady.
paragraph of the
Starts
judgment.
at paragraph 3.
Parties, the last page judgment.
Exactly.
Sorry.
There's a sort of element of unreality about this hearing because the fact is I found that the husband was the owner of accounts which held a very significant sum in them, approximately 20 million. I ordered him to pay a lump sum of 6 million. Said in my judgment I didn't know where that money was and I didn't know how it had been utilised, and the balance of probabilities I found he still had a significant part of that money. Then he goes to deal with Mr. Haggie's submissions at paragraph 13. Mr. Haggie, who appeared as junior counsel at trial and appears on his own today, set out various matters which asked me to draw conclusions based on the recent accounts of IIB, which employs the husband, which is largely owned, I think it should read, by him. I do not think it would be proper for me to draw the conclusions that he asked me to draw. So he very specifically did not draw any conclusions that the IIB was a resource to the husband. He declined to draw those conclusions. What he goes on to say is what I think he can properly say is that so far funds have been required of the husband for his costs, some of them for applications which had never been brought, he's always found the funds. Of course, he's continued to his credit to pay maintenance at the rates been ordered. He's managed to meet certain other obligations and he's incurred significant indebtedness to his solicitors, who are apparently prepared to play the long game, and also to his father. And then he goes on at paragraph 14. Then I come back to the findings. So he specifically declined to make any findings that my client had any other source from which to meet any legal fees. And what the Court of Appeal found is that he was entitled to take into account all his findings, but it wasn't a finding, as we can see at paragraph 33, that he had any other resources available to him. The whole thrust of the judgment comes down to paragraph 14, in which he says, I'm entitled to take into account the disputed accounts. And so we say that today, this court needs to give fresh consideration to my client's means, as it's bound to do, either on an unless order, as we will see in a moment, under a Hankinson application.
Are we moving on there? I'm conscious of the times.
I'm moving on to the Hankinson. I know that your ladyship is well versed in the Hankinson jurisdiction.
Well, a long time ago, though.
It was a long time ago. May I take you to page 46 of the combined authorities? And that is the case of DeForge. And paragraph 11, Mr. Justice Jackson said this: for present purpose, it's enough to note the exceptional nature of the order and to recall the conditions that are necessary before it can be made. I would summarise these as follows, and you're familiar with those. And then it goes on at paragraph 16. In my view, this is a plain case in which all the essential criteria for a Hankinson order are met. Is the husband in contempt? Yes. He is in breach of both orders. Is his contempt deliberate and continuing? Yes. And this is really the nub of it. He is silently disengaged in the midst of his own appeal. So the facts of that case were very different from the facts of the instant case. Is there an impediment to the course of justice? Yes.
Compliance with the legal services payment order is essential to enable the wife to participate in the husband's appeal if indeed he seeks to pursue it. Is there another realistic remedy? No. And so the facts of that case, as I say, were very, very far removed. And if I can take your ladyship to your case of C&C, and again, the facts, just to set it in context, the facts were radically different from the instant case. There was an egregious breach, we say, of the freezing order. The husband had diminished by extraction the value of his primary company, but critically, he never suggested to the court that he could not afford to fund the award. And there's a helpful analysis, we say, from paragraph 19, which your Lordship, your Ladyship will find it starts at page 16, paragraph 27.
Paragraph 27.
Paragraph 27.
Thank you.
And might I ask your Lordship, your Ladyship, to read paragraphs 27 and 28?
Certainly.
And then I'd like to focus on paragraph 29.
Can I just check what is meant by should the court exercise its discretion to impose jurisdictions?
I have to say, I think that's a miss. I think that's a typo.
It's conditions.
Yes, I think so.
Yeah.
Sorry about that.
Sorry.
My proofreading's not improved, I should say.
And can I take you to paragraph 29 and focus on that? During the course of his judgment in Lang and Lang, Mark Potter indicated he didn't find the use of the expression utilised by Mr. Justice Riding Ruback, contumacion, a helpful one, when applied to the willful nature of the contempt relied on to found the Hadkinson jurisdiction. He said at paragraph 24, I do not regard the word contumacion as a useful addition or supplement to the threshold requirement that the contempt should be willful, in the sense of voluntary, deliberate, knowing and continuing by a person well able to comply with the order if he or she chose to do so. Once that threshold is established, in deciding whether or not, to what extent to fetter the right of the applicant to proceed with an application for variation, relief by imposition of conditions, it would be relevant for the court to take into account the level of defiance displayed as well as its effect. And then it goes on at paragraphs 30 and 31, and then we cite from Justice Bodie's judgment. From all the above, I conclude that non-payment in breach of a matrimonial order to pay money itself is in itself a contempt of court. There is, in my judgment, no requirement that it should be shown to have been culpable, either non-paying party had the means to pay. I disagree with the conclusion of Ryder J to the same effect. I repeat that in Gower, the husband's non-paying of the cost was specifically held not to be willful, yet he was described by the court as being in contempt by the mere fact of such non-payment. In my judgment, therefore, questions of culpability come into play as regards the court exercising discretion as to whether and how to act on the contempt so established. At that stage, all the circumstances, I think again there's a word missing, have to be considered. Crucial, if not decisive, was, and I emphasise, be whether the non-paying party could have paid if he had wanted to. And then going on to paragraph 32, relevant to the issue of willful refusal in Lang, Smart Potter reminded those hearing this type of application that the mere fact the husband may have a legitimate argument in support of his application for reduction of maintenance on the reduction of his own income doesn't legitimate his willful failure to make payments due under the court order, given his ample means to pay out of current resources. And then paragraph 33 cites again Smart Potter and Sharman. In this respect, in the light of the authorities, I do think it helpful to concentrate on events pre-judgment, particular steps taken by the husband with a view to obtaining as low a reward as he could, or some other result satisfactory to him as an indication of whether security is appropriate post-judgment. Seems to me at best that is background on what the court is concerned with is the extent to which the judge can be shown to be in breach of the trial judge's order and bent on non-compliance. And so, and then we go on paragraph.
You're stressing as I understand it, you're stressing that to found a Hadkinson order, you need to have somebody who is able to pay but deliberately doesn't.
That's all the authorities.
Okay, is your client's position at the moment? I don't have any funds with which to pay, so you shouldn't make a Hadkinson order against me. But if I were to obtain some funds, then I wouldn't pay the court orders because I will pay my solicitor instead.
No, that is what my solicitor is saying. I can't answer for what my client would do. My solicitor is saying that she would not continue to act. I think there's a significant difference there. I think your lordship is with respect, putting it at
conflating the two situations.
Exactly.
Although you're...
My client would find himself without a solicitor. That would be the net effect. If my client was to be able, and I stress to be able to raise some funds, which he cannot do. So I think the lordship have the point. And if I can just go briefly to L and O, which was a decision of Mr. Justice Cobb, where he declined to make a Hadkinson order.
It was a very different case, though, wasn't it?
Oh, it's very. It's a very different case, which is where the husband bought a barter application. It's a different case, my lady, but there is, I would say, a relevant thread. In that case, the husband bought a barter application, saying that there was a substantial and unanticipated drop in his fortune. And he's saying that, from recollection, it had a devastating and irretrievable impact on his financial situation. Well, my client isn't quite facing an identical situation, but he's facing a situation where the court has found he has an account with 12 million, and he's saying, no, I don't, and he has permission to appeal. So there are some parallels, but I can't say that it is identical. And what Mr. Justice Cobb said at 67, paragraph 19, if I could just ask you to read 19, 20 and 21, then I will take you to paragraph 25.
Sorry, can you give me the page number again?
Oh, I'm so
67.
sorry. It's page
67.
67
Thank you.
of the authorities bundle.
Right.
And then you're taking us to where?
Then paragraph 25 and 26. so in paragraph 26, the husband did bring 25. He brought his difficulties to the wife's attention and her solicitors, and he carried on paying her maintenance without missing a payment. And then in the centre of paragraph 26, at the hearing in July 24, I will need to undertake a proper investigation of the husband's BARDA claim, and insofar as a supervening event was not foreseen, the apparent impact which the BARDA event has had on his financial portfolio. And I draw a parallel to that in my client's appeal. I'm not convinced it's right to restrict the husband's access to the court by requiring him as a condition of the pursuit of the claim to place £750,000 into the frozen account. There is a risk, it seems to me, that such an order may lead ultimately to injustice. I should add as a footnote that he did make a security for costs order in the second part of his judgment. But we would say that the parallels between that case and the case ought to have bearing on your lordship's decision. So where does that take us? In short summary, my client has obtained permission to appeal and a stay on the lump sum. He has sought to engage the wife, as your lordship has read my client's statement in the exhibits to it, he sought to engage her in some kind of settlement discussion. That hasn't worked. He accepts that he's in contempt, but he asserts with considerable force that that contempt is not deliberate, and it would not be appropriate in the circumstances of this case to stifle an appeal. The only source of funding which Sir Jonathan Cohen could find to fund the LSPO award was the £6 million, as is evident from the judgment. And I would invite the court to read the statement that he has filed, which set out his financial circumstances. And if the court has any questions in respect to that statement, other than ones already posed by his lordship, I'd be perfectly content to answer them.
Thank you. Just a minute, Miss Pango. No, I think we're clear. Thank you very much, Ms. Pango.
You are clear.
Yes, thank you very much indeed.
I might just add that within the exhibits are the letters where my client has tried to engage the wife in settlement discussions in advance of the appeal, and also subsequent to the LSPO, because my client can't afford this litigation any more than the wife can. And of course, the result of the appeal, if he's successful, is that it will be remitted, probably for a rehearing, if the £6 million finding is set aside. And what we proposed was that the wife accepted the appeal and it was remitted for a rehearing, which we would hope would be inevitable.
Thank you. Now, Mr. Richardson, what have you got to
My lady, my
say
lord,
to us? A lot, I suppose.
I'll be very brief.
Of
You'll have
course.
seen from my skeleton argument that,
Yep.
that I came into this hearing, as it were, at that stage, anticipating that no orders of substance were being sought against my client, and I was
Yes.
here for case management purposes.
Of course.
We then received my own friend's skeleton argument yesterday, which at paragraphs 33 and following appeared to intimate that, in fact, a had Hinson or an unless order was being sought against
Well, you're not
my
in
client.
contempt, so I think you can relax about that.
I was not relaxed, my lady. I prepared
No,
a
I
stream
imagine.
of submissions for you on the
But
point.
I mean,
But we've
from
heard
what
from-
Mr. Glazer said in his submissions,
He's not moving that application today, it appears now.
In the skeleton, it says the application the wife seeks at the end is per her applications, which don't involve an order against the bank.
I agree, my own friend's applications didn't. His skeleton argument, as I say, intimated something quite different. However,
Well,
since he's not moving...
Did it?
Paragraph, if you look at my own friend's skeleton argument,
Yes, I have it.
paragraph 33 at the top, my lady, at the
Except that the
heading,
bank's not in breach.
he says, the unless order, Haddington order should apply to both appeals. And then at 39, at the bottom, you'll see he says,
Sorry, you're going to get 33.
paragraph heading at 33, the unless order, Haddington order should apply to both appeals. And then at 39, he says various things which we would take exception to were I to need to address you on them in the following paragraphs. But then at paragraph 39, he says, in light of the bank's past treatment of its resources for its own benefit, the bank should not be entitled to the customary respect paid to a third party. As a Thomas resource, and I would take exception to that, of which the husband is in control, it's not unfair to expose them to collateral pressure. And then if the order was not made to encompass the bank, the husband could prosecute his position through this company. And then he says, Hadkinson's order can be made in cross-related proceedings where there are circumstances to permit it.
Yes,
and he refers to an authority.
That which wasn't in the first authorities bundle because I had to dig it out to read it. And
Indeed, and
to
also
say that that issue is dealt with briefly and raises all sorts of issues.
It does, and critically for our purposes, it was the husband who was in contempt in one set of proceedings, who was debarred from pursuing another set of proceedings as a result of the Hadkinson. It was in no sense a situation in which a spousal party was in contempt and then a third party was debarred from pursuing a proceeding.
Yeah. Well,
so
we're
as
all
we
clear
read,
now.
we are now, thankfully. All I wanted to say, given where we now are and given the time, is that whilst there was quite a lot I would have wished to address you on about inaccuracies in the account given of the bank's position and what happened below, I don't intend to do that unless you want me to, and I suspect you don't, but I just wanted the transcript to be clear. There was a lot in what is said by my own friend that isn't accepted by my client.
Understood. Thank you.
Do you have a comment on the timing of the bank's appeal?
I do. I've taken very brief instructions.
Yes,
I think we'd be content with 2 months following the sanction period, as your lordship called it. What we would request, however, is that the listing is also by reference to the convenience of leading counsel.
I think that's right.
Well, I apologise if there's any ambiguity in our skeleton argument. I thought it made clear at the beginning and the end what we're actually applying.
Well, it foxed me too, if that's any consolation to Mr. Richardson.
Just a few matters in response.
Yes.
It's a curious position in relation to the husband and his solicitor. One questions whether there's a conflict of interest because his solicitor is saying, unless you pay me in breach of a court order, I'll cease to act for you. It's also curious in that the husband has paid Miss Bangay for the original appeal trials, right, as well as the appeal. As I understand it, 2 payments totaling £24,000 was paid to his solicitors for the appeal before Lord Justice Moyland and his other judges, the other judges in that court, in a letter. So the position appears to be curious in what the husband's solicitors are willing to allow him to do when in breach of a court order. But that's a matter for them, really. But may give an eye to the statement that my lord drew Miss Bangay's attention to about the issues between the two of them. What essentially is being said is that, by Miss Bangay, is that they want to relitigate the question that was dealt with by Lord Justice Moyland. Yes. Because he summarises or encapsulates the terms of the appeal before the court on that occasion in paragraph 28 of the transcript, the typed out judgment. And those are the submissions. So I don't know whether you found it. Sorry,
yeah.
Paragraph 28. The encapsulation of the husband's appeal.
Yeah.
And that's exactly what's being said to this court today. The court has to take into account in our submission the findings of Sir Jonathan Cohen, which were upheld on appeal. And the upholding on appeal was that it wasn't just about that one account, it was all of Sir Jonathan Cohen's findings. And so what the encapsulation of the ground of appeal that was dismissed was essentially that there are other resources of the husband from which he could meet the award. So you're being asked to revisit, rehear collateral attack on the decision only a couple of weeks ago. Completely impermissible. I agree with Mr. Richardson about listening for council convenience, and we'll need to deal with timings about skeletons and respondents' notices and such like in due course. But, yeah. Is there anything else I can help my lady, my lord, with?
I don't think so. No, thank you very much indeed. That's very helpful. Well, thank you all very much indeed. May I thank again particularly solicitors who've managed to put together very helpful bundles and authorities bundles for our assistance today, and we're very grateful for that. You won't be surprised to hear that, notwithstanding that this is a case management hearing, roughly said, that we will be reserving our judgments in this, but obviously we will intend to get our judgments out as speedily as possible, and certainly well before the Easter vacation. You'll be sent a draft in the normal way. Can I, for consideration of typographical and factual errors and proofreading, given the state of C&C. But obviously the embargo applies, so please be conscious of that, everyone, given the potential commercial sensitivities so far as the bank is concerned. I'd hope you thereafter will be able to agree any orders between you, but we'll deal with any other matters in writing.
The only other matter just to raise with the court, because it was part of my lady's order and Mr. Richardson made mention of it in his skeleton, was the question of costs. It appears from Mr. Richardson's skeleton that he was applying against my client for the cost of the appeal being adjourned, which is surprising given that we would say that it's down to the husbands. I don't know whether my lady, my lord, wishes to hear submissions on that, or I only mention it because it's part of.
Well, we have the submissions in writing, unless anyone's got a.
We haven't responded to them because.
And that wasn't my submission in my skeleton, wasn't intended to be. At that stage, when I had understood that I was here for case management purposes only, my submission was simply that, as between IIB and the wife, the costs of today ought to be costs in the appeal.
In that case, there's no issue.
Certainly. Well, everyone, Ms. Bangay, you presumably have no comment to make about that?
None.
Thank you very much, Mr. Richardson. That's helpful. Anything else that we need to deal with today? No? Thank you all very much.